Bismillahirrahmanirrahim. It will be more of an interactive session and we will try to get to the depth of the topic. The topic, as you know, is jurisdiction of commercial courts and importance of ousting clause in contract. Basically, two different topics have been clubbed together in this. Basically, one important phrase is the jurisdiction. That is the part which you are dealing with it, which is a bounden duty on you, which I will tell why. And then there's the topic of ousting clause. First of all, let's go back a bit before getting into this topic. Why we need commercial courts or a commercial court ordinance? Basically, you went through a workshop in September and most of you were there. The foremost question among was that what is a commercial dispute? Those sort of questions were creating problems for the participants because there was no framework at all. So our judiciary, our superior judiciary was also cognizant of this fact, and then when the ordinance came, if you look at its preamble, it caters for two things. It says that it is providing us this ordinance because it needs to cater for modern trade and commerce, which requires special expertise. So there was a need of specialist judges to deal with specialist matters. So there was an understanding the present civil structure wasn't dealing with cases that efficiently. Hence they brought in this ordinance. Secondly, as in the earlier part of the day, we were talking about that there were delays. So a procedural framework was also needed to cater for those deficiencies. So we had this commercial court ordinance. Now we come to the part of ousting clause. What is an ousting clause or the ouster of jurisdiction clause? Basically, if you look at it from a narrow angle, basically what ouster clause does, it tends to limit your jurisdiction. Basically, it is taking something away from you. If you see a contract, basically all of you are concerned with contractual disputes. You are not concerned with contract drafting. When a person is drafting a contract, what he is doing is that he is looking at two things which are very important for the parties. If you enter into a commercial contract, you want that if for any reason there is a dispute, I need to get this dispute resolved. So if I want to get this dispute resolved, what sort of court will look into it? So here comes basically the forum for resolving a commercial dispute. So there can be a two forum depending on the agreement. Modern commercial contracts, if you look at it, because you are dealing with it, most of them will contain arbitration clauses. So basically arbitration clause, what it is doing is that it is taking something out of the jurisdiction of courts. Why it is doing that? Because in arbitration there is a realization that courts are not suited to cater for our needs. So basically they want to settle it outside. And secondly, what litigant want is that he has to be sure that what sort of law will be applied to his court, because there are foreign parties involved in commercial contract. They would not like that Pakistani law would apply to their case. So there will be a choice of law clause. There is a forum selection clause and there is a choice of law clause. So why these are brought into it? Because a commercial party wants certainty. I would just read three lines which I recently took from Lord Mansfield, and I wrote it in my article. That will highlight my point much better. Basically what he said was, in all mercantile transactions, the great object should be certainty, and therefore it is more consequence that a rule should be certain than whether the rule is established one way or the other. Basically what is being said is that certainty is the key. A party is not interested that this is a landmark, that his case will become a landmark judgment and will get reported in PLD or SCMR. He wants certainty in his commercial transaction. What he is paying something for for it, he expects that he will get that thing. If he doesn't get it, he wants that legal system to help him to get to that. So basically, that's the role where you come in. Basically, I touched upon that one of the type of ouster clause is the Arbitration Act or 1940. You have seen that act. You must have dealt with that act. What that act does? Anyone? What is Arbitration Act providing? Outside the court. There are basically three different processes it provides for. One is without the intervention of the court, and then by the parties with the intervention of court, and third, there is where there is a suit pending and all the parties agree upon, and then they say that this matter be sent for arbitration. Suppose I am talking about second scenario, arbitration with the intervention of court. Suppose there is a suit pending with you and there is an arbitration clause, and someone files an application and says that this matter be referred to arbitration. What will you do? Agreement is clear, it says it is for arbitration, because you have to read that in context of section 19. All of you must be aware of section 19 of the Punjab Commercial Court Ordinance 2021. If you can have a look, you all will have a copy. Before, it gives an overriding effect to this ordinance. So basically it is potentially excluding effect of Arbitration Act 1940. That can be problematic. Secondly,
this ordinance provided the matter shall be referred for
alternative. Yes.
Maybe
In future. I'm just pointing out the legislative gaps. You will face these problems in your dealing with the cases, because I think at present this is not a perfect piece of legislation. Still, long headway has to be made into it. But those legislative gaps have to be covered by you. Because if you have to see, because in enforcement of contract indicator, if we are at 152, why we are that? First of all, there is no certainty regarding enforcement of contract, and secondly, the way we are dealing with contractual disputes. So you have a bigger task. So you have to take these things into account. I am just highlighting few of the problems which I have seen. Because why I am focusing on that, I would like that every one of you should look at Commercial Courts Act 2015 of India. It is a much better crafted piece of legislation. And I would like to refer to section 10 of that. And how do they deal with that? Jurisdiction in respect of arbitration matters. There is a specific clause provided for that, because they didn't wanted to have that potential conflict. What does that say? Where the subject matter of an arbitration is a commercial dispute, sub 3, in such arbitration, all applications or appeal arising out of such arbitration under the provisions of Arbitration and Conciliation Act 1996 that would ordinarily lie before any principal civil court of original jurisdiction in a district shall be filed and heard and disposed of by the commercial court. So they are expressly giving jurisdiction to our commercial courts. So basically, if an award is decided, so that award will be filed in a commercial court in India. But over here we will have that potential conflict, because what you see, you have been given, basically what I would say is one of the finest work which our civil courts are performing, that has been given to you. A very small chunk is left with them. So basically, if the arbitration, all of that comes to commercial courts, that will be dealt in a very proper manner. Secondly, there's another ouster clause, another type of ouster clause. Generally, if you look into the acts, they have ouster clauses as well. I would again refer to the Indian Act. I would like to read small portion of section 11. What that says: bar of jurisdiction of commercial courts and commercial divisions. What it says: notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application or proceeding relating to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred under any law for time being in force. Basically section 9 CPC. But we haven't catered for this eventuality. So basically, what potential conflict can arise out of this? Suppose there is a banking FIO 2001 is there, banking courts are there. A matter similar to that comes before you. So this act is not providing you clear guideline. I will come to that. Just hold on for a second. Commercial dispute 2D, I will touch that, because that definition you have rightly pointed out, that is a deficient definition. And why is that? There are three glaring problems with that. I'll just come to that. It just caught me. Court. Definitely. No, definitely I am coming to that. Jurisdiction of commercial courts, I am just coming to that. As you have pointed out, what is jurisdiction of the commercial court? That has been carved out by section 2D. But before going to that, there is an important question. Basically, how does the question of jurisdiction arise? You have to look to section 7.2. Section 7.2. Can anyone read? 7.2. Yeah, 7.2 of the ordinance. I'll just read it. On presentation of the plaint, before issuing the notices or the summons, it shall be duty of commercial court to prima facie satisfy itself of the jurisdiction. Number one is jurisdiction. Number two is the cause of action, and number three is the limitation through a speaking order. So basically, a duty has been cast upon you through this section. So basically, a claim comes before you, you have to determine jurisdiction. How will you determine jurisdiction? You have to go to section 2D and section 3(1) and 5. So now before going to that, we will just touch section 2D. Why? Because section 2D talks about many things, but it gives a value, 500,000 rupees. It talks about pecuniary jurisdiction, but it fails to pinpoint the process through which you will calculate pecuniary jurisdiction. So basically, what party has said, either you have to believe that. So let's see how you tackle that. Secondly, as far as territorial jurisdiction is concerned, have a look at section 3, subsection 1. Basically, the government will issue a notification which will establish commercial courts, like Lahore Commercial Court has been established, that will define territorial limits. But there's nothing much more than that. Subsection 5, what does that say? Subject to provision of this ordinance, all suit proceeding arising from or connected with commercial disputes shall be entertained, heard and decided by commercial court. So basically, all of it will come to you. So these are the two things. But what is the problem with the term commercial dispute? Now if you once again look into section 2D, it is a very deficient definition. It has made your task very difficult, because what it says, it means any dispute can have multiple forms. Claim or counterclaim arising out of contractual dispute where the value of claim or counterclaim is 5,000 rupees or more, or such other value as the government may notify, related to or connected with a transaction of trade, business and commerce, excluding sale or purchase of immovable property. This potentially raises three problems. What? ये प्रॉब्लम वाला को, ये बहुत ज़्यादा प्रॉब्लम वाला है. क्यों है? काम कर रहे हैं, इसीलिए तो बेसिकली जो अर्लियर आए हाँ जी, तो यही आपने उस चीज़ को हिट कर लिया. और दूसरा प्रॉब्लम क्या है कि जब आप एक्सक्लूसिवली सेल एंड परचेज ऑफ इमूवेबल प्रॉपर्टी को एक्सक्लूड कर रहे हो, तो आपके लिए प्रॉब्लम आ रही है कि चले सूट फॉर स्पेसिफिक परफॉर्मेंस तो समझ आता है, दैट विल नॉट कम टू यू, मगर बाकी कंस्ट्रक्शन कॉन्ट्रैक्ट्स हैं मल्टीपल. आज जिस तरह नया हाउसिंग पाकिस्तान प्रोजेक्ट, दूसरे मल्टीपल काम हो रहे हैं, दे आर ऑल रिलेटेड विद प्रॉपर्टी. हाउ आर यू गोइंग टू एक्सक्लूड दैट? वो प्रॉब्लम आएगा. वो ये अब आपने डील करना है. हाँ जी, वो ये आपने डिफाइन करना है. मगर आपको देखें अदर साइड से भी लॉयर ने आना है ना, तो उसने तो आपको परसुएड करना है ना अदर वे राउंड. मेरा खाली काम क्या है कि वो हाईलाइट करने हैं जो पिटफॉल्स मौजूद हैं, क्योंकि जो इंडियन एक्ट है ना उसमें इन चीज़ों को केटर किया हुआ है. मेरा यही होएगा कि जब प्लानिंग एंड डेवलपमेंट डिपार्टमेंट देखिए, दिस इज़ एन ऑर्डिनेंस, इट हैज़ टू गो थ्रू लेजिस्लेटिव प्रोसेस. वंस इट गोज थ्रू दैट लेजिस्लेटिव प्रोसेस, दीज डेफिशिएंसी हैव टू बी टेकन इनटू अकाउंट, क्योंकि वो अकाउंट करेंगे तो तभी आपके काम में सर्टेनिटी आएगी. वरना तो देखें ना, यू आर क्लियर इन योर माइंड, बट समवन सिटिंग in Gujranwala, he might not be clear in his mind at that time, and you are all are uploading your judgments. ठीक है, तो वो difference of opinion would come up. और problem पे pitfall सबसे बड़ी क्या है कि there is an appellate tribunal. ठीक है, appellate या तो होता है ना कि if high court has the jurisdiction, there is a commercial division of high court dealing with that, there would have been certainty. There will be commercial appellate tribunal all over Punjab. So difference of judgments might come up, and that will create uncertainty. That will be problematic. Now coming back to what are the pitfalls with section 2D, I see three problems. What if part of claim is related to recovery of property, which you have answered, and I agree with that. Others should also follow that, but that will create problem. Other is, what if relief asked in the suit hinges on sale of property? That will be a problematic area. And thirdly, what if one of the contracting party is state? Because if you see, Pakistan is a very small economy compared to other economies. Our basically government spendings move this cycle of economy. If government spends in a year, it moves many businesses. So if you are excluding government or their agencies, I am saying if you potentially exclude that will, I think, will make commercial courts redundant. So I think legislation has to cater for that, because if you look at Indian definition, what they have done is, I would just like to read a proviso. That is an excellent one. They have defined commercial dispute in section 2C. I would not go into their detail because that is a very exhaustive definition, but what they have done in the end is that there is an explanation with many things. So if you assume that jurisdiction on the basis of purposive interpretation, that will be another thing, but there are potential pitfalls that have to be looked into and have to be corrected very soon, because if you look at it, the way they have applied, they have tried to limit CPC application to this, that doesn't fit well. So there are potential gray areas which you people have 4 days to look into it and highlight. Basically, whatever the feedback you will give and whatever we are saying, and this will be taken into account at the time the draft is draft is placed before the legislature. Now I would come to the recent judgment of Pizza Hut judgment delivered by Justice Jawad Hassan, 2021 CLD 639. This this is an important judgment because this came at the time when there was no legislative framework. Basically, you all were working on the basis of a notification of a high court. There was no act supporting you. So basically, you must all have read that judgment. I would just like to pinpoint to para 24. It's an excellent read. What it says: before parting with the judgment, it is observed that the commercial courts which are established by the Lahore High Court in Lahore, Multan and Faisalabad for time being are meant to secure expeditious disposal of cases of commercial nature within the scope of Article 202 and 203 of the Constitution. Article 37D of the Constitution also provides that it is duty of the state to provide inexpensive and expeditious justice to the people. Therefore, the commercial court which is seized with the matter in hand is directed to seek guidance from Rule 10 and 11, Chapter 1K, Volume 1 of the Lahore High Court Rules and Order, and from Judgment 1995 MLD 1707, wherein this court has directed the learned trial court to follow Rule 10, Chapter 1K of the High Court Rules and Order, Volume 1, in case of commercial nature which mandates as under. So basically, even the superior judiciary was cognizant of the fact that there are gaps. They came up, even the act was not there, they took the help from High Court Rules and Order and they provided a ground for you to play in. So basically, keeping in mind this proactive approach and with the similar support coming from the bench, I think, ये citation 2021 CLD 639 आपको नीली बुकलेट आज दी है, उसमें भी ये वैसे है उसमें ये है, उसमें तमाम कमर्शियल कोर्ट्स के आर्टिकल्स भी हैं। जी सर, ठीक है। तो ये है कि वो पे ऑर्डर 37 के तमाम दावे आपके पास आ गए। हाँ जी, हाँ जी। तो ये मेरा तो सीरियस कंसर्न है कि सेक्शन 2D नीड्स टू बी रिविजिटेड। नहीं, मैं तो इसी चीज़ में, मेरा नेक्स्ट आर्टिकल जो आई एम गोइंग टू राइट वो इसी चीज़ पे लिखूंगा। हाँ जी, तो वो मैं उसी पे जो है ना फॉलो, बल्कि उसमें से अगर आपके वो भी आपके उसमें मौजूद है, उसमें बल्कि मैंने यही चीज़ जो आपको बताई है वो उस वक्त भी लिखी है। ये उसका उसमें पैरा तो नहीं, ये सब पेज 10 में CLD में है। वो the term commercial dispute has been defined in section 2D of the ordinance as a dispute valuing as Rs 5 lakh or more arising out of contract relating to or connected with any transaction or trade, business or commerce between domestic companies or foreign companies or firms। अब इसमें देखिए कहीं गवर्नमेंट का जिक्र ही नहीं है, गवर्नमेंट को वो इंटेंशनली ओमिट कर गया है। अब वो आपके कंधे पे है कि आप उसको किस तरह से डील करते हैं। सेकेंडली, हाउएवर इट एक्सक्लूड्स कॉन्ट्रेक्चुअल डिस्प्यूट बिटवीन इंडिविजुअल्स and dispute involving sale and purchase of immovable property in least। अब ये मेरी ऑब्जर्वेशन उस वक्त की थी जिस वक्त ऑर्डिनेंस को भी आए हुए 1-2 दिन हुए थे कि in initial days of commercial courts this section 2D will be center of dispute as most modern transactions revolve around immovable property and a narrow interpretation of this section can restrict the jurisdiction of commercial court. Furthermore, at present it is not clear what will happen where if one of the contracting party is government. If the dispute involving government are excluded from the ambit of this ordinance, then whole exercise of being establishing commercial court might not be well received in sectors where huge investment is government projects are being carried out by foreign companies firm. Hence it is advisable that before the ordinance is tabled by the Industries, Commerce, Investment and Skill Development Department in Punjab Assembly, an amendment be proposed with the objective of bringing clarity on these lines। तो बेसिकली ये आपका हमारा मिल के काम है। ये इस चीज़ को तो हमने देखे, एक वर्कशॉप का मकसद ही यही है कि इन डेफिशिएंसी सब अच्छा कहने से तो नहीं अच्छा होएगा ना। जी,
Like this they oust ordinary jurisdiction. They define how they are going to settle their dispute. If a foreign company or two companies, they entered into a contract and they have a valid arbitral clause in their agreement, and a party comes in this court and they file an ordinary suit. So how we can comply with that arbitral clause in their agreement, which is valid all around the world except Pakistan? Because if we don't agree on the arbitral clause, so that's why we are not directly encouraging their point of view, because
Definitely.
we are putting it in a normal procedure in a civil suit. So I think there is a major gap here.
I totally agree with you. I totally agree.
How we can
Well,
address this
Jurist.
running case.
Welcome. So this has to be taken care of. Otherwise, there will be a big problem for us. देखें ये बना ही नहीं है. Commercial courts, as he has rightly pointed out, जो बड़ी multinationals हैं, if they are dealing privately, even आपने हबको के केस में दूसरों में देखा, they had foreign arbitrations. Even आपका जो था बलोचिस्तान वाला जो Recodic वाला, they had these arbitration clauses. They don't trust our system. They take their disputes outside. But we are trying to create an environment where we want that even our domestic companies, at least they should trust us. They should get some sort of relief. As Taimur Malik in earlier part of the day was pointing out, that it is not about only foreign investment. It is also about us. You have to realize that we have a big population, more than 22 crores population. That is more than sufficient to uplift an economy. We have a growth of 4%. How? Through domestic consumption. We are a major market. We have to realize that. The problem is we are not facilitating each other. Because if a guy comes, invest 10-12 million in an investment project, next day he comes, he realizes that company is no more. So who is going to facilitate? It is you people who are going to encourage them. But the pitfall is that heavy onus is placed by Section 7 regarding jurisdiction. That is a big trap. So if you interpret it very narrowly, you would be discouraging litigant. I think major work should come to commercial courts and it should go through you. So you should be open-minded. Because I think there's a general perception which is very wrong our judiciary cannot deliver. I think they can deliver, but they have not been provided the right platform. But you guys are fortunate that you have been provided that platform. And if you are able to play, I think you will play wonders for our coming generations. Thank you. Any question? Sir. जी जी हाँ जी, विद पैसेज ऑफ टाइम. मगर अब देखें ना, अगर इससे एक ऊपर चले जाएं, रूल 22 भी है रूल मेकिंग का. अब देखें ना, जितनी केस मैनेजमेंट है, ये सारी चीज़ें हैं, इसको अगर प्रोएक्टिव करना है, सारे मामलात करना है, तो दे हैव टू बी विजिलेंट. इसके लिए गवर्नमेंट रूल मेकिंग में इन्वॉल्व है. प्लस जो इंटरेस्टिंग एक और फीचर है ना, कि हाई कोर्ट ने अपना भी रिटेन इसमें है. इसमें बेसिकली आर्टिकल 203 बेसिकली सुपरिटेंडेंट्स तो हाई कोर्ट की ही है. मगर अगर आप इसमें देख लें सेक्शन 18, व्हाट डज दैट से? सेक्शन 18, पावर ऑफ द हाई कोर्ट टू इशू डायरेक्शंस. तो बेसिकली अगर इस तरह की कोई बहुत बड़ी एनॉमली आ जाए, मसला आ जाए, तो वहाँ हाई कोर्ट डायरेक्शंस भी इशू करके डायरेक्टली इस ऑर्डिनेंस की प्रोविजन को सप्लीमेंट कर सकती है टिल द टाइम कि लेजिस्लेचर उसमें इंटरवीन करे. तो वो भी मौजूद है. जाहिर बात है, इट इज़ नॉट डिजास्टर. मगर ये है कि कोई स्टार्ट है, तो स्टार्ट में देयर आर गोइंग टू बी प्रॉब्लम्स. ये नहीं होगा कि आपको एक CPC की तरह एक परफेक्ट डॉक्यूमेंट मिल गया जिसके साथ आप प्ले करें ना. आपके पास देयर इज अ डेथ ऑफ जूरिस्प्रूडेंस एज वेल. वो तो शुक्र करें कि अभी हाई कोर्ट उसमें जो है ना जजमेंट्स दे रही है, तो चीज़ों को क्लैरिटी आ रही है. वरना देयर इज नॉट मच मोर टू लुक इनटू. تو اس لیے ضروری ہے. اور اس میں ہے کہ آپ کا آپس کی بھی کوآرڈینیشن بڑی ضروری ہے. دیکھیں کیونکہ آپ کا ایک چھوٹا سا بیچ ہے اور آپ پورے پنجاب کو چلا رہے ہیں. اگر آپ کی آپس کی ڈسکشن اسٹرانگ ہوگی تو ایک وہ سرٹینٹی والا فیکٹر رہے گا, کیونکہ میرا تھرو آؤٹ فوکس ہی سرٹینٹی پہ کہ آپ کمرشل مرکنٹائل ٹرانزیکشن میں سرٹینٹی لے آئیں, باقی یہ قوم خود کر لے گی. جی کوئی نہیں, اچھا میں تو آپ کی وجہ سے سمجھا کہ وہ اچھا اچھا اچھا, یہ تو پھر وہ تو آپ ریسورسز کو پھر ویسٹ کر رہے ہیں نا. کیونکہ دیکھیں یہ ایکسپرٹ کام ہے, یہ اس طرح نہیں ہو سکتا کہ آپ نے سال 2 کر لیا. بیسیکلی یہ تو کنٹینیوٹی ہوئے گی تو یہ سسٹم میں سرٹینٹی رہے گی, ورنہ دیکھیں نیا بندہ آئے گا وہ اتنی جلدی ان چیز باریکیوں کو پکڑ ہی نہیں سکے گا, کیونکہ مرکنٹائل ٹرانزیکشنز کی لیئرز ہیں. یہ اس طرح سمپل نہیں ہے کہ آپ نے پیسے دیے اور چیز لے لی ہے. اب تو لوگ کرپٹو کرنسی کی باتیں کر رہے ہیں, وہ معاملات چل رہے ہیں, ڈفرینٹ ایک ڈائمنشن اور ایڈ ہو رہی ہے. شیئرز کی سیل ہیں, فیوچر سیلز ہیں, سارے معاملات ہیں. تو اس کے لیے کنٹینیوٹی ضروری ہے تاکہ چیزوں پہ گرپ ہوئے. چلیں یہ آپ نے اچھا پن پوائنٹ کیا, یہ تو میں بھی جدھر ہو گیا. اچھا میں اسی پرسپیکٹو سے کہ اس وقت ہم بات کرتے تھے نا کمرشل ڈسپیوٹ کے کیا آئے گا, رینڈیشن آف اکاؤنٹ کا کدھر جائے گا, معاملات جائیں. تو یہ سارے یہ پٹ فالز ہیں. اور پھر دیکھیں نا کہ چیزیں آگے چیلنج ہونی ہیں, معاملات ہونے, پھر چیلنج ہو کے چیز ریمانڈ ہو کے آئے تو نقصان کس کا ہے؟ نقصان تو لٹیکنٹ کا ہے. سرٹینٹی پھر سسٹم میں نہیں آئے گی. انفورسمنٹ میں پھر اگر آپ نیچے رہتے ہیں, چاہے باقی انڈیکیٹرز آپ جتنے اوپر کر لیں, اسی نے ایوریج آؤٹ کرنا ہے نا. وہ ایک ہی پوزیشن آپ کو اتنا نیچے لے جائے گی کہ آپ کی رینکنگ کبھی بہتر ہی نہیں ہو سکے گی. تو اس لیے یہ ضروری ہے اس چیز کو کریں. ہاں جی, اب یہ ہے نا, مگر اس کی آپ دیکھیں نا اس کے پیچھے بھی وہ اس وقت کے حالات تھے کہ آیا تھا ایک دور تھا کہ سی این جی اسٹیشنز اور سارے معاملات تھے اور بڑے بڑے لوگ تھے جو گرفت میں آ نہیں سکتے تھے, وہ ایک اسپیشل پرپز کے لیے لائے. مگر اس کا دیکھیں کہ اس میں اسٹیک ہولڈرز کون ہیں, کہ آپ کی اپنی جوڈیشری نے اتنی زیادہ ایفرٹ کر کے, کبھی دیکھیں اتنا انٹرسٹ لیا ہے میں نے تو اپنے نہیں کیریئر میں آج تک اس طرح دیکھا کہ بٹ بائی بٹ کر کے آنریبل چیف جسٹس کا دیکھ لیں, جسٹس شاہد کریم صاحب, جسٹس جواد حسن صاحب, مطلب کنسسٹنٹلی لگے ہوئے ہیں, مطلب اور وہ انٹریکٹ کر رہے ہیں کہ یہ کرو وہ کرو. مطلب وہ ہر کسی کا, ابھی اگر آپ اپنی بکلیٹ اٹھا کے دیکھ لیں کہ سنگل ہینڈیڈلی 5-6 اس میں آرٹیکلز ہیں. اب اس ساروں کے پیچھے دیر از ون مین جیسے جواد حسن, میں نے سب کو کہ لکھو لکھو لکھو. ہمارا پرابلم کیا ہے کہ ہم لکھتے نہیں ہیں. ایز اے نیشن جو پرابلم ہے, ہمارا لا کا ڈکلائن کیوں آیا؟ کیونکہ لکھنے کا فائدہ کوئی نہیں ہمارے سسٹم میں. اگر دوسری جورسڈکشن میں دیکھیں نا, آپ لکھتے ہیں, آپ کی اکنالجمنٹ ہے, آپ کی ایون پروموشن چیزیں اس چیزوں سے لنک ہوتی ہیں. یہاں ہم رائٹنگ کو ویٹیج ہی نہیں دیتے, جس کی وجہ سے نہ کوئی لکھتا ہے اور کانسیکوینٹلی نہ کوئی پڑھتا ہے, تو معاملات ڈکلائن کی طرف ہیں. اچھا اب میں کہا اب آپ کے میں چائے بریک کا ٹائم نہ لوں. ٹھیک ہے, تھینک یو جی. مگر کہ یہ اس پہ کنٹینیوسلی ایک دوسرے سے ڈسکس کریں.